Agenda item 7 is consideration of petition 1458, which is a proposal to establish a register of judicial interests. I refer members to paper 4, which is note by the clerk. Do members have any comments or questions? John Finney.
Thank you, Convener. Yeah, I thought it was very interesting contributions we had there from the Cabinet Secretary and from the various judicial people, and indeed, finally, comment on each of these from the petitioner. The debate seems to be pretty polarised, and I understand it's a considerable number of years that the petition's been open, and I'm very keen. I think there is an issue here that remains undealt with. I think the public would anticipate that there is some measure of accountability there. I note the comments that are said about intrusion into the independence of the judiciary, and I wonder if there's an opportunity perhaps to investigate that further as a way of going forward. I'm conscious that this has been around a long time. I mean, I'm supportive of the principle. I note everything that's been said, but we seem to have hit a bit of an impasse, and I would be keen to hear the views of people like constitutional lawyers.
Yes, Liam MacArthur.
Thank you, Convener. I very much agree with John Finney. I think intuitively I find myself supportive of the idea of a register, but I don't underestimate some of the concerns that have been raised by the Cabinet Secretary and representatives of the judiciary, particularly around the independence of the judiciary and all this. The debate is rather polarised. It's difficult to see where compromise might be possible here, but I just wonder whether or not we might proactively elicit views from perhaps academics in this area, with a view to maybe testing some of the arguments that have been made to us in the helpful evidence that we're looking at in this meeting.
Rona, then Alistair.
Thank you, Convener. Yeah, I mean, I think this is an issue. It's a very important issue, and it's one that I think will not just disappear. I think it's something that we as a committee should investigate a bit further, take some wider evidence so that to inform our views on it. And I'd be in favour of doing that at this stage, albeit it's, you know, we have, as John says, reached a bit of an impasse. I think it's incumbent on us to take a wider look at it for the time being.
Alistair, then James.
Yes, like the others have said, this is clearly an important issue, and one that probably merits us having a conversation or a discussion about in committee. I think on principle, the only thing I would add is that if the petition has been in the system for 8 years, I think we should take evidence with a view to bringing the matter to a conclusion. I don't think it's fair to have petitions in the committee for that length of time without bringing them to some kind of conclusion, but I would be happy enough to hear evidence on it.
Rona? Sorry, Rona's being James.
Thank you, Convener. I've become convinced of the case for a register of interest in relation to the judiciary over the period that the committee have been examining this issue. Note the responses from the Cabinet Secretary and Lord Carloway. Clearly we've got a bit of a standoff here, and I think the suggestions that members have made to try and take additional evidence to take it forward is sensible. I don't think we should park the issue. I think this is an important issue, and we should continue to press on it.
Okay. Are there any other views from members of the committee? I should just say that I think there's one petition that we've been dealing with at least has been even in excess of 8 years, and that's the McGrackie case petition. But as you say, not ideal. So would it be fair to say then that given the impasse, diametrically opposed views, and in an effort to move forward, then the committee would seek further information and a non-record in session with perhaps constitutional lawyers and others, with a view to looking at the pros and cons of the petition, and will then take a formal decision, and also ask maybe Spice and the clerks for a note of these wider issues, perhaps even taking into account just any other conflict of interest issues which might have a bearing on how court decisions are taken. Liam?
Yeah, I would agree with that. I think the format of that evidence session maybe better be carried out through a round table rather than a more traditional evidence session. And I think in the information provided by SPICE, due to the fact that it was referred to by the Cabinet Secretary and previously by the petitioner, the situation in New Zealand appears to have taken a different course. It would certainly be useful to have an understanding as to the kind of thought process they've gone through to arrive at the decision they have in relation to this same issue.
Okay. Are we all agreed then? That's the way forward? Thank you.